I'm going to be speaking about these three cases, and full disclosure in advance, I was counsel to the hospitals that were involved in each of these cases. Different levels of involvement, nature and degree of involvement differed in terms of the hospitals. And a shout out to Erica Barron at McCarthy Tetro, who another U of O grad from 2000, who represented the physicians in each of these cases. So speaking about what the media would refer to as the brain death cases. So these two, I'm going to talk about the cases somewhat together because they did run parallel with each other, with some similarities and some very significant differences. Most similar about them is that they both involve patients who were young with strong undiseased hearts, which permitted them to be physiologically maintained for extraordinary periods of time. Just a bit of background. We knew going into these cases that the Supreme Court of Canada had already decided that the withdrawal of mechanical ventilation from a comatose patient required consent. And if the consent from usually a substitute decision maker was not considered to be, or if the refusal to consent to withdrawal was not considered to be in the patient's best interest, it could be challenged to the Consent and Capacity Board. But being comatose is not the same as being neurologically determined to meet the criteria of death. Medically, the difference between a comatose state and brain death is very clear. It's virtually impossible for physicians to confuse the two states, but there is a lot of confusion around that among lay people and particularly in the press as well. Post-Rizzulli, the Consent and Capacity Board had had a few cases brought to them for direction where families were refusing the withdrawal of mechanical ventilation from brain dead patients. And the CCB actually refused to take jurisdiction on those cases. And that's why these cases, the Wanunu case and the McKitty case, both went directly to a judge of the Superior Court and not first to the Consent and Capacity Board. So with that background, it's always been assumed that consent was not required for the withdrawal of mechanical ventilation and other intensive treatments from a patient who has met the criteria for neurological death. It's always been the practice to where families are having difficulty coming to grips with the withdrawal to allow for some grace period, or what others might refer to as accommodation, to allow those families sufficient time to come together and come to terms with it. That's what in practice happens in hospitals when we get these sorts of difficulties. So getting to the cases. The McKitty case, as you can see, a 27-year-old, and this is the case that went forward. Initially, the hospital was a party, but very early on, the family was persuaded to release the hospital from the legal proceeding, as the decisions in question were decisions of physicians, not hospitals. So that needs to be clear. Hospitals don't make decisions around whether the continuing treatment is of any benefit. They don't make determinations of death. They don't tell physicians when to withdraw or not to withdraw treatment. These are clinical judgments made by physicians, and therefore there was no point in trying to enjoin the hospital from doing or not doing something. In the McKitty case, it started very much as a family who simply could not believe that their daughter did meet the criteria for brain death. And it was over time that it took on the added feature of the family saying that it would contravene their daughter's religious beliefs, that she believed only in a death by cardiac arrest. And I've set out on this slide the way that the case went forward. We had a very thorough decision from the Superior Court judge, which was upheld by the Court of Appeal just over a year ago. So in essence, we're back, as a result of that Court of Appeal decision, we're back to this being the status quo. And I'll come back to some of the reasoning in a bit. The Wanunu case, again, this time a young man, and you can see if you go back that the time frame was very similar. They were both in hospital at the same time in the same month, having been declared dead by neurological criteria. The basis for the religious argument in this case was far more extensive. The evidence that was led with respect to the religious belief was without doubt. There was no doubt that this was a patient who believed that he would not be dead unless and until his heart stopped, and that everything must be done in the meantime. And it was also a case where the hospital was kept in as a party, and that led to there being far more evidence before the court with respect to not only religious beliefs, but also the ethics, the clinical bioethics piece of it, as well as what happened in other jurisdictions in similar situations. So that, I mean, the thrust of which was the only jurisdiction in which one would continue to maintain physiologic support of a brain dead patient in the manner that was being asked for in this case would have been New Jersey. And the evidence established that in New Jersey that would have been at private expense and not funded publicly by the healthcare system. So it made for some very interesting evidence. But as you can see, what happened was when the patient died before the judge released the case had been fully argued, but the cardiac arrest occurred, and then they had the decision of Justice Shaw in the McKitty case, and therefore the judge decided that the Wanunu case was moot and declined to render a decision in that case. So that body of evidence went unexamined. So how did the scarcity or the cost of the healthcare resources factor in with respect to the clinical decision making? Were the physicians thinking about this as they declared death? No, it was not a factor at all. But you could see from the reasons of Justice Shaw in the McKitty case that she was certainly affected by the knowledge that there could be implications for our public healthcare system should patients and families have the ability to demand ongoing care that was clearly not going to lead to any improvement. And so it was for these sorts of policy issues that she declined to create an exception to the common law definition of death, which includes both cardiac arrest and brain death. So she basically said, I'm not going to do that. I will leave that to government. On appeal, the court, and I've underlined Justice Miller's name because he's the one who wrote the reasons. Dismissed the appeal, but did so on different grounds than Justice Shaw. So they accepted that the common law definition of death included death by neurological criteria, and that one could not, on the facts of this case, insist on further. But Justice Miller, and agreed by his brother judges, was not prepared to say that there wouldn't someday be a better evidentiary record that might permit the court to carve out a requirement that accommodation or exception be made for those with religious objections to to a death by neurological criteria. So it made it more sad, I guess, that the Wanunu case had been dismissed as moot when there was so much more of an evidentiary record in the Wanunu case. Having said that, it was also missing the Attorney General as a party. Notice of constitutional question was served in both of these applications, and the Attorney General declined to involve themselves. So I think what we can expect in the future, if there are similar challenges made to the common law definition of death, that we might see the Attorney General step in to defend the current state of the law. Moving on to the next case, I'm going to talk about, and this is the case that asks the question, do you need consent to write a no CPR order for a patient where CPR is medically considered to be of no benefit whatsoever and in fact may cause harm. So as I said, the facts are obviously a very severely ill man admitted. It was not a lot that could be done for him. It was expected that there'd be a slow decline toward death. Discussions with the daughter, who was a substitute decision maker, who insisted that he remain full code. And so he was full code. He underwent bilateral amputation as an effort to control pain. It didn't work very well. He was transferred to the ICU post-surgery, then back to the floor. And back on the floor, that he only started to deteriorate further, and the physicians became very concerned that he was approaching death and that CPR would cause him untold suffering and not be of any benefit, would not save his life. And so there was, can you change, next slide? So there was an examination of the patient by a critical care physician together with the MRP, and they also consulted with the critical care physician who cared for him when he was in the ICU, and concluded that they should write a no CPR order, which they did together with a thorough progress note. And they were expecting that he would die within the next few days. Next slide. The daughter was contacted to be advised of this decision. A voicemail was left without detail. They didn't connect before she actually arrived in the room. There was an unexpected precipitous decline of the patient, and he suffered a respiratory and then cardiac arrest in her presence and in the presence of other staff members. The physician was able to arrive at the bedside quite quickly, confirmed the no CPR order, and the patient passed away in a situation that was extremely traumatizing, not only to the patient's daughter, but also to those staff who were in the room. Next slide. So what then happened was, I'm not going to get into the details of this slide other than to point out that from 2008 up until 2016, there were 3 trips back and forth between colleges and the Health Professions Appeal and Review Board, not only with respect to these 2 physicians, but that's the one that went on the longest. And in the meantime, the College of Physicians and Surgeons of Ontario amended its end-of-life policy twice while the case was ongoing, and they've since amended it again, as James will get into more detail on. Next slide. What also happened in addition to the college and HPARB matters was that there was a lawsuit started against the hospital and the physicians. And as I said, it took 11 years for it from the start of the incident until the case was resolved. And on the eve of trial, not quite the eve, but close to trial, the decision was made by the plaintiff to agree to let the hospital out of the action. So the hospital, and represented by me, was not present at the trial in the form of being a party, but hospital witnesses were called for the defense and gave evidence that supported the physicians in the case. And the result was that the case was dismissed, the physicians having been found to have met the standard of care and complied with all relevant law and policies, including the CPSO policy, as it all was as at 2008. That decision is not going to be appealed, and so it's a lengthy judgment. It bears reading, and I commend it to you. Next slide. So some of the points of interest, contrary to submissions that were made repeatedly that the Rizzulli case meant that consent was required to write a no CPR order because it amounted to a withdrawal or withholding of care. The judge disagreed, and it was confirmed that the Rizzulli decision is confined to the requirement for consent for removal of life support from a comatose patient, not for the withholding of CPR. a no CPR, next slide, a no CPR order essentially means that there's been a clinical judgment made that CPR will be of no benefit and is simply not on offer, and you don't need consent to not offer something. And the writing of the order is simply a documentation confirming what is not being offered, so that those at the bedside know that they don't have to provide CPR as the usual fallback in the absence of an order. Next slide. The other big issue was, okay, well, that may be, but this patient had been full code all along as a documented order, not just as the fallback. And so that was changed, and surely the change in a course of a plan of treatment requires consent. And the judge said, no, you don't need consent to take something off the table. So the similar situation that was persuasive in this regard is in an oncology. If chemotherapy is being provided to a patient and it becomes clear during the course of that therapy that A, it's not working, and B, it's only actually causing harms to the patient, the physician is able to say, I'm stopping this course of chemotherapy. They don't have to give in to a patient who says, I refuse to consent to you stopping the chemotherapy. Similarly, prescribing opiates. If a physician prescribes a 10-day course, the patient can insist that prescription be continued. You don't need consent to not continue to offer opiates. Those are some of the arguments made that I think were persuasive for the judge. Next slide. Talked about the common law standard of care, and so the Healthcare Consent Act does not apply. What about the common law standard of care? A reference to Justice Karakatsanis in the Rizzulli case, who was one of the minority judges in that decision, one of the Ontario judges, and adopted the concept that physicians can't be forced to provide treatment that violates what they consider to be within the standard of care. So next slide. In the Wawrzyniak case, how did the scarcity or cost of healthcare resources factor in? Again, not at all. At no time was it ever suggested that this was a concern around not wanting to kind of waste resources on Mr. Daguerre. Did not factor into the clinical decision making. I think that it certainly probably was in the back of the mind of the judge that it was important to clarify that medical care can't be provided on demand if it's not within the standard of care. The scarcity or cost of healthcare resources, there was certainly evidence in the brain death cases as to the cost of providing ICU care to patients and the impact that it has when the beds are scarce on the care of other patients, the impact it has on staff. That was in the Wanunu case that didn't get decided. But I think today, given our pandemic situation, I don't think there's much doubt that we do have to have this concern. Next slide. This is an anticipated legal development. This has been a work in progress, the concept of providing guidelines to permit the triage of critical care in a pandemic situation. It's been going on for years, back since when we feared that the H1N1 virus may become a pandemic. Work began on developing policies. They got shelved for a little while, and they've come back with a ton of work going into developing at least province-wide, if not Canada-wide, protocol. There is as yet no framework legally for such a protocol. It obviously would it implies that there would be withdrawal of ICU support as well as withholding from patients without consent. The only criteria being clinical criteria as to the short-term mortality risk, and the application as much of possible of non-discriminatory criteria to triage patients. James will talk about that in more detail in the pros and cons of such a protocol. But as I said, it's a ethical framework, it's a medical framework, and it is not as yet incorporated into a legal framework, and we'll have to see where that goes in the very short term. So that's the end of mine. I'm going to hand over to James now and look forward to answering any questions you may have.
Thank you so much, Daphne. And I am going to share my slides. Can you see those okay?
Yeah.
Fantastico. All right. Just want to disclose I've received some speaker fees for topics that have nothing to do with this. I've received grant funding to study triage decisions and outcomes, and I'm the co-lead for the triage framework, as Daphne has mentioned. So those are my potential conflicts of interest. I'm going to try to pick up from Daphne as much as possible. I want to leave some time for discussion. So again, if you're multitasking and catching up on your Twitter feeds, these are the three main points that I would like to sort of convey today. Number one, that the CPSO policy that sort of developed in the wake of the Wawrzyniak case, or as the Wawrzyniak case was unfolding, really the latest update from last year is, I think, an improvement in the sense that it allows appropriate medical care. I have ongoing concerns about it, though, because it does tend to encourage miscommunication and poor care. I want to convey the point that there really does need to be a medical standard of care for critical care and end-of-life care, as there is for every other aspect of healthcare. Because that's really the only viable structure on which you can operate. And I'm then going to finish off with talking about the critical care triage protocol and try to convince you that really they are necessary for the sort of twin goals of reducing preventable deaths, but also mitigating the effects of implicit biases on clinical judgment. So picking up from where Daphne left off, you know, when the Wawrzyniak, in the wake of the Rizzulli case, as the Wawrzyniak case was going through its sort of third go around at the CPSO opted to change its policy in September 2015, the policy for planning and providing quality end-of-life care. And at that point, they sort of said that, again, a unilateral decision about no CPR cannot be made by the physician. That if the patient or substitute decision maker disagrees with a unilateral no CPR order and insists that CPR be provided, physicians have to engage in a conflict resolution process. And that conflict resolution process was fairly detailed, but it included a number of things that probably were not appropriate to the situation, like the consenting capacity board, where it was rarely the question. Consenting capacity board isn't really convened for medical standard of care. It's more about what the patient would have wanted. And it wouldn't apply if, for example, there was a competent patient, or if there was a prior applicable capable wish. They wouldn't have any scope to answer questions of medical standard of care. Again, importantly, from our standpoint, the challenge was that while the conflict resolution process was underway and there was no prescribed end to the conflict resolution process, basically it ended as soon as everybody agreed, which often doesn't happen. But if an event requiring CPR occurs, that physicians have to provide CPR. In so doing, physicians must act in good faith and use their professional judgment to determine how long to consider providing CPR. We wrote a commentary at the time, and I'm going to sort of make reference to a few articles to read in more detail that I won't get into here. But really, I think we tried to highlight the fact that, you know, this was a really quite a troubling double standard to treat CPR and ICU as things that are given by default, that you need consent to not give them in a sense, which is different than every other treatment. And our story is, you know, if there's a person who comes into the emergency room, so a gentleman gets sent in by their GP saying, oh, you've got advanced cancer and a bowel obstruction and you look like you're in septic shock, you should go to the hospital where they'll give you critical care, they'll operate on you, and they'll treat your cancer. So you've got this patient thinks they've given informed consent for a treatment plan to treat all of those things. They come into the emergency room. The emergency doc calls, they've got a metastatic cancer that's causing a bowel obstruction and the person's going into septic shock. So they call the surgeon, the oncologist, and the intensivist. And the surgeon walks in, looks at the person, and says, look, I can't operate on this. This isn't going to help. I'm not offering surgery. And the oncologist says, look, you're way too sick and this cancer is way too advanced. I can't treat you with chemotherapy. It's going to do more harm than good. I'm not offering chemotherapy. And the intensivist says, look, you know, you've got an underlying unfixable problem. This septic shock is just the latest manifestation of it. I can't fix what's underlying all of this. You're never going to get off the ventilator. I'm not offering critical care. If the person then goes on to die, according to CPSO policy, The surgeon and the oncologist are acting within their scope of practice and within the medical standard of care, but the intensivist could potentially be subjected to a complaint that would be upheld by the CPSO. And it was situations like this that continued to sort of play themselves out across the province, and people getting calls and referrals to CMPA and CPSO about this that was a problem. At the end of the day, our concern was that CPR should not be treated differently than other treatments at end of life. Ultimately, what drives this and the concern that people had for family members that were potentially looking at grief or conflict, that this was a hope of trying to resolve some of those, that CPR actually wasn't the best way to try to address grief or conflict. And that if this was viewed to be a clash of values, CPR isn't a value. CPR is a treatment. It may reflect a value. There may be values that can inform this, the choice of treatments like CPR or chemotherapy, but CPR itself is not a value. There's no ancient cultural documents that make reference to CPR as being something sacred that must always be provided. The other big question, of course, is what to do while the conflict resolution thing is playing out. That if saying that, if the person arrests during the conflict resolution process, you must provide CPR and use your judgment for how long to provide it. The problem, of course, is that the only reason you're in that conflict resolution situation is that you've already said that you don't feel that any amount of CPR should be provided, that the appropriate amount of time to provide CPR is 0. So how can you in good faith start doing it? And how, I don't know what the appropriate duration of inappropriate CPR is. Unfortunately, it encourages slow codes that you kind of have to run a code, but knowing full well that it's not appropriate what you're doing, you're not, how do you know what to do? What is an appropriate step for a procedure that you feel is inappropriate? Ultimately, the people focused on trying to get communication and consent, focused on communication and conflict resolution is one thing, but forcing people to get consent doesn't necessarily drive them down the conflict resolution pathway, because the path of least resistance is to simply say full code, we'll run the code. And of course, there was nothing in the policy that mandated anything about comfort care, that you still needed consent to provide comfort care, which we know and believe to be a standard of care, and that's problematic. So again, when this case went to court, and I think I'm not going to dwell on this because Daphne's already mentioned what the findings of the justice were, is that it's not, that you don't need consent to enact on the DNR order, and upheld it as well under common law. And that ultimately led the following month to a revision of the CPSO policy, saying again that they felt that physicians cannot unilaterally make a decision regarding a no CPR order. But in this case, if something happens while conflict resolution is underway, physicians must provide all resuscitative efforts required by the standard of care, which may include CPR. So again, not saying it ruling out, but you don't have to do it. I should note that that was a sort of temporary stopgap measure. They had planned to do a revision in 2020, and then there was something about a virus that came up, so they put it off until 2021. But I'm told that it is definitely happening in the next couple of months, that they're starting that process. So again, another analysis, and I'll refer you to this article to go a bit deeper from a medical standpoint into this, that our current state, of course, is according to law in Ontario, we believe that you can withhold CPR and life support without consent, but you can't write a no CPR order without consent, that it has to be sort of a clinical decision made at the bedside according to policy. And of course, according to Rasuli, you can't withdraw life support without consent. So that's a bit of a goofy situation. You don't have to give it, but you can't write an order saying that you're not going to give it. You have to wait until it actually happens and then say you're not going to give it. And again, the common law interpretation, which I think Daphne's already mentioned. So the concern then is that it allows us to do the right thing in terms of not providing CPR that we feel is inappropriate, but it potentially encourages a problematic practice of these sort of miscommunication slow codes. So you say, well, okay, I can't write a no CPR order, so I'm just going to say that you're a full code, but I'm going to put a big asterisk and say that we don't feel it's medically necessary. So I'm saying I'm going to do one thing while knowing full well that I'm not going to do that, because there's nothing that's going to change between now and when that person arrests that's going to make them more likely to survive or make me think that it is appropriate. And I think that's a bit disingenuous. I think, the core of trust and communication is you should feel comfortable saying what you're going to do, and you should act on what you say you're going to do. There shouldn't be a gap or a disconnect between what's written in the orders and what you intend to do in practice. I just don't see that that's a good thing. It does lead to questions about, the distinction between when we think something is outside the standard of care versus just not a good idea. And that would be, we have to, we struggle in many aspects of medicine to define explicit standards of care for lots of things. Sometimes it does come down to judgment and weight of opinion. But I think that having a more clear and explicit standard of care would be a really good thing. But at the end of the day, I think the underlying problems that drive this are not addressed by anything in law or policy, right? That at the end of the day, I think that in the post-truth world, and I don't think it's just post-truth, but I mean, there really is an underlying current right now of questioning and being highly skeptical of anything that might be thought of as expertise. Anybody who's in a position that we might call power or privilege is inherently questioned. Their motives are questioned. Everything about what they do and say is questioned. And Google MD often tells you what you want to hear, which is maybe better than what you're hearing from the doctor in front of you. And why isn't that? I mean, why should I accept your expertise when I'm hearing something different? And this is much more appealing what I'm hearing here. The conflict resolution pathways in general have always been far too slow to be effective. The decision to initiate conflict resolution is a decision to provide open-ended critical care, because you can just continue it indefinitely. There is no endpoint to conflict resolution unless you go to the Supreme Court. That takes a very long time and an awful lot of money, and that's not really a fair way to be adjudicating these things. And again, the idea that no trial. So the idea that you're handling from a medical legal standpoint, withholding withdrawal differently is problematic, because then the decision to initiate becomes really impactful, because I have the power to not initiate, but I don't have the power to withdraw. So I need your consent to withdraw. And if you withhold your withdrawal, if we decide we agree on a trial of therapy that lasts 3 days, and then after 3 days we say the trial isn't going well, we're going to stop, the subject decision maker or patient can withdraw their consent to the trial, and then you have to leave them on open-ended critical care, which is a problem. I'm going to finish off with a couple of key points about triage. Number one, that there are two real harms in an overwhelming pandemic. One is that preventable deaths will occur. These are people that might have been able to be saved had you given them critical care resources, but you just didn't have enough. And the other thing is that there's a restriction of individual rights. So things that you normally would want to receive, that you would be entitled to receive within the standard of care, aren't available and you don't get them. So it's a harm in terms of your life and in terms of your human rights. I would argue that clear frameworks are really the only way to try to mitigate both of these harms. You're trying to do some sort of medical utility analysis to save as many lives as you can, prevent as many preventable deaths as you can, but also having explicit standards that then limit unjustifiable effects of a pandemic on certain vulnerable groups. You're trying to promote consistency and transparency in your decisions. You're trying to mitigate the trauma to healthcare providers that don't have to sort of do this off the cuff or hold a wet finger in the air when they see somebody at the bedside and feel like they're kind of on their own. At the end of the day, triage is terrible. The alternatives are worse. You want to have, when you're designing an approach, you have to have certain concerns, right? So we're trying to save lives. We're trying to establish consistent approach across regions to treat people with different diseases and conditions the same way based on their mortality risk. You want to use equity approaches, mitigate biases and subjectivities, because people left at the bedside, this is where the disability community or people with chronic disabilities or other vulnerable groups may appear or believe to be having elevated mortality risk, but don't, will be treated as though they have elevated mortality risk and denied critical care access, or perhaps on a subjective judgment about their quality of life, be denied access to critical care. And that's the real danger that you want to mitigate against. That's why having clear protocols to forbid that kind of thing and establish the way in which one should make decisions are kind of vital. You must be transparent, right? Standards for decision-making, appeals and accountability all have to be in there. You want to be proportional, right? You don't want to triage any more than you need to. So having a bit of an adaptable system based on the degree of surge is important, and it has to be usable. The other key point here is that all of this is driven by the fact that you have more patients than you have ventilators. So the option of, we don't think we should make triage decisions, we don't think we should make resource allocation decisions, that option's not on the table. The only options on the table are first come, first serve, which is our default. You wait till the units are full and then you close the doors and turn everybody else away. There will obviously be some selection in that. There's random allocation, meaning that you have probably a lot of preventable deaths that will occur because you are giving the same weight to somebody who's potentially in an advanced state of illness than you would be to somebody who may have decades to live or have a very high chance of survival. Or you can use some sort of hybrid approach where you're doing triage, either using categorical exclusions, a scoring system, or prioritization, as some people might have seen in Pittsburgh, or a hybrid model like the one we're using. Again, to quote Churchill, democracy is the worst form of government except for all the others that have been tried. That's the same way you have to look at triage, right? That again, you may not like aspects of what we talk about when we talk about triage, but literally every other approach, I think, is worse in terms of either potentially putting human rights at far greater risk, the disability community at far greater risk, and also increasing the number of preventable deaths that occur. Those are real harms that need to be mitigated. Other key thing, right? We're the fire department. We're not the fire. There's a lot of talk and people sort of getting very upset with people involved in development of triage protocols, as if to say that these are the people who would be responsible for the violation of human rights or deaths among certain population. I think that's really misguided. What's causing all of this is the fact that we have facing an overwhelming surge in demand. And if that occurs, that's the driver, right? We are the fire department, we're not the fire. And you don't yell at the fire department, okay? You may not like how the fire department's going about trying to put out fires, but the harm was caused by the fire, not by the fire department. Transitioning from promoting individual survival to population survival is what you have to get your head around when we're doing this. And this has been shown multiple times in surveys and standards of practice around triage, all focus on the idea of optimizing population survival. It is a different mentality. It's not one we're used to. And that's, I think, difficult for some people to get their head around. I'm going to sort of move along and wrap things up by just sort of saying, look, nobody's ever tested a pandemic triage framework. So to say that things are evidence-based or proven, I think is incorrect. And insisting that we only use things that are proven is inappropriate, because that's obviously an unattainable standard. There is no perfect approach to doing triage and balancing priorities, right? But there are no unicorns out there where you get to save all the lives and protect all the rights and nobody gets harmed in a situation of overwhelming surge. That option's not on the table. But understand, right? Like if you're going to criticize an approach, you have to say you must provide an alternative approach that you think balances priorities better than the one you're criticizing. And that's what needs to happen if we're going to have a real discussion around triage and triage tools. So I'm going to stop there because I think that's the end of my slides. And thank you for your attention. And I'm sure we're going to get some questions and discussion.
Thank you both so very much. Daphne, I invite you to come back onto the screen too, and I'm going to go to the Q&A. So all of you out there, please do send in your questions. I see that one question has come in for the speakers, so I'm just going to pass it along to you. So the question is, the effectiveness of the COVID triage protocol depends largely on an emergency order to suspend the Healthcare Consent Act and the requirement to obtain consent to withdraw life-sustaining treatment. When can we expect a decision as to whether this order would be given if needed to suspend the consent to WLST requirement, or can that order only be issued when it becomes necessary?
So it's a good question. In July, the government suspended the Emergency Measures and Civil Protection Act declaration of an emergency. We're into a different legal framework now. So for there to be an order made suspending provisions of the Healthcare Consent Act under the Emergency Measures and Civil Protection Act, there's going to have to be the re-declaration of an emergency under that act, and then an order. I'm sure it is, but I'm not involved at all in the process. I'm sure it's very politically fraught. It's the sort of declaration and order that no government would ever want to have to make. And I'm sure they're going to wait until it looks like it needs to be made. And in the meantime, there's sufficient communication. I don't know if it was early enough, but the protocol itself is being communicated through to hospitals so that they can start to get their heads around the organization internally that will be required in order to implement it when the time comes. I don't know if James has more intel than I do.
No, I think that's exactly right. And again, just to be clear, I think you can prepare to do something without actually doing it or without actually having the executive order in place that allows it. And if that's the compromise, that's I think a lot of people are okay with that idea, understanding that this may need to be a last minute, sort of stamp. That you need very little approval to enact an executive order. We do need a lot of preparation to enact a triage protocol. It's not something you can just load into a syringe and inject like a vaccine.
another question come through. A question about the composition at the CCT table, COVID triage table, I think. And the question is, were there citizens, patients, or other stakeholders, or is it primarily bioethicists, physicians?
So yeah, okay, the table where this document was generated was actually very few physicians were present at the table. It was largely bioethicists, other members of the sort of broad ethics community who are not necessarily practicing bioethicists. There was a lot of consultation with stakeholders and disability groups as well over the course of the summer. But important to also recognize that almost everything that went into that document, I mean, we didn't invent it at the table. So there's been a huge body of literature and stakeholder engagement, survey work, small group work, and bioethics work that's been done over the past 10 years, and sort of a project and a group of projects known as CanPrep. So this was like grant-funded stuff that took place in Ontario, specifically about values and norms that should inform our approach to a future viral pandemic where critical care resources would be under strain. So again, I would say that a lot of stakeholder engagement took place in the form of that work. That obviously the work took place before the start of this pandemic, but I think it's fair to say that there was a lot of stakeholder engagement. I think there's never too much stakeholder engagement. Always need to have more. At the same time, we also need to have a working document to go forward with, because there's no point in having a plan if we're not ready to use it at the time that it's needed.
A follow-up question to the first question posed about the order suspending the application of the Healthcare Consent Act. And something I was wondering about too. So I'm putting it to you on behalf of myself and one audience member. So question is, in the absence of an order, would there be any legal protection for physicians to enact the protocol?
God, I hope so.
I think so. It's certainly not a statutory protection. I don't think it's going to fall within the current bill that will grant immunity for where someone gets COVID. It's different than that. But it is essentially it's adopting a pandemic standard of care. It is recognizing that if factually we get to the point where resources are overtaken by demand, people are going to die. And therefore, it's a good thing to try to keep that number of deaths to a minimum. And the best way to do that is with some objective, broadly recognized appropriate criteria that have been developed by a process that James has outlined. That is, I would be surprised if a judge were to find that there was a negligence for having in good faith applied the protocol in a situation where otherwise it's going to be more random and numbers are going to increase in terms of deaths. But we have no precedent to go on. That's like, I think I could make a good argument, and I'm pretty certain that a judge would accept that argument. And there's, we've certainly done lots of research, and we know that there is a body of literature that supports that argument. So fingers crossed. I feel quite confident about it, but no guarantees.
I was thinking ask a question. I'd be very interested to ask Daphne's opinion on this, and yours too, Jennifer. The flip side is, if we're saying that all the ventilators are occupied, and this conversation is coming up in the context, and decides we're not going to exact the executive order, physicians are on their own, and a physician decides not to engage in applying this kind of triage approach. In other words, somebody who has a very survivable condition comes in needing critical care. The ICU is full, so we're first come, first serve because there's no alternative. So we say, I'm sorry, I'm not taking you to critical care. So you're denying that person standard of care that they would benefit from unilaterally because they want it and they would benefit from it in favor of something else. Would I be liable as a physician in that context? Could I be sued for not having provided it, knowing with the argument that the standard of care in such an environment actually is to apply some sort of medical utility and use your resources better than I've used them? I'd be interested to hear Daphne's take on that.
Well, as I've always say, and you can always be sued. Someone's going to sue you.
That's very comforting. Thank you. No, I feel better.
But you know, first of all, the implication is that that wouldn't happen unless and until everything else possible within reason had been done. So, you know, have you tried to transfer the patient to centers that have...
Assuming all of that's been done. I didn't give the ventilator to this person because it was being used for somebody else who was obviously not going to survive.
Yeah.
Or almost certainly.
So as I would foresee that situation, that's not going to be the call of an individual physician. It's going to be called by, you know, someone at the command table, even if it's not government, right? So it may not be cabinet, it may not be government, but there's somebody who is in a very senior position within the critical care community in the province who's going to say, we've been keeping our eyes on the resources and on the demand, and we believe that we are now in a surge position, and we would recommend that this protocol be followed. That's what I would envision. I wouldn't envision that an individual physician is going to be making that call. So that's the protection that will be there. And, you know, even if it's just at a hospital level, that, you know, the hospital's own pandemic, I'd call it pandemic committee, they all have different names, but those who are kind of keeping track of what's happening in their own hospital and doing their utmost to cooperate with other facilities to share the resources, that they're going to know when that moment comes, and the physicians will hopefully have that degree of guidance at the very least.
I was thinking about it also, not just in the negligence context, but potential battery claims for withdrawing someone from a ventilator, and necessity defenses and things like that is another. Yeah,
no, it's a very, I mean, it's all to say that, you know, by far it would be preferable if there was statutory, a statutory framework, which whether it's by order in council or immunity or whatever, but that there's some legal statutory framework that gives the people the requisite degree of comfort, but that there are other types of comfort that can be given.
There's a question directed to Dr. Downar. What are the implications of the decision by Justice Kavanaugh for the decision to withhold mechanical ventilation in cases where survival to liberation from the ventilator seems very unlikely to the attending physicians? Are these implications worked out?
Yeah, so I mean, thanks, Ewan, for the question. And yeah, I mean, the short version is I think many people have stated that under common law, that right really didn't exist. I think most people agreed on that as much as anything. In terms of, you know, the gap potentially is that, does this conflict in any way with CPSO policy? And I think it's felt to be enough of a gray zone for many people that they will offer it anyway. But I think that if it does anything, if it does add a little bit more clarity to the idea that you do not have to escalate, I think it seems very unlikely. And as I've said, I think my biggest concern about that is that, you know, because there may be such a discrepancy then between how we treat withholding and withdrawal, that it is a very strong disincentive to trials. And as you well, and we all know that there are many situations where it's obviously like, you know, this is really not going to work. There's some where we're almost certain it's going to work. And then there's a few in the middle where you're like, you know, this might work. Like a short trial, if this turns around really quickly, then this person actually could benefit. And I'm just not sure. I'd love to be able to offer this trial, knowing full well that I'm not committing this patient to open-ended critical care, because the framework as it exists essentially makes the family member the one to have to push the button to stop it, and all the guilt that gets carried with that. I'd love it if we could have a paradigm where a trial is a trial.
I want to just bring us just back to brain death and bring the brain death disputes together with this discussion about withholding, withdrawing, and all that sort of thing. And so one of the solutions to disputes over brain death would be just not to argue at all over whether brain death is death, but to just not escalate care of the brain dead person. And this is one recommendation that's being made. And in many cases, the person will likely proceed to cardiac failure relatively swiftly. Now, as you pointed out, in the younger patients, this might not be the case. It might go on for some amount of time. One possibility, potentially, I'd like to just run this by you and see what you think from legal, ethical, and maybe the psychological perspective for patients, one solution would be to go further than no CPR, no escalation of care, but just no, what's the word I'm looking for? I'm losing my word here. No application of the next dose of medication. For example, when one dose runs out, it's not reinstated. So in essence, things come to an end and they're not restarted. So it's a form of, it's turning a withdrawing into a withholding, as it were, right? And so given Wawrzyniak, would that be the kind of solution where you're not providing the next dosage of vasopressors, the next dosage of the kinds of things that allow the slow stability?
I would say, from my perspective, the point you're just making highlights the importance of why I think it is a good idea to not draw a distinction between withholding and withdrawal, because literally every decision in critical care, in medical care, could be framed as a withholding or a withdrawal, depending on how clever and smart you want to be, right? So again, it's, you know, this Wawrzyniak being the classic example. It's like, no. It's like, well, look, we withheld critical care. We're allowed to withhold. No, you didn't withhold critical care. You withdrew a plan to provide critical care. And then that plan, of course, exists by default in everybody. So every decision to withhold is actually a decision to withdraw. You know, how many angels can dance on the head of a pin?
But do you think there's a psychological benefit? Does it feel different to the patient to actually unplug something versus not to?
Oh, 100%. And I think you see that across the board. The withholding versus withdrawal is a really big distinction. And very often we in critical care are used to this. You see people from certain cultural backgrounds, and it's not always cultural, but sometimes framing something as a non-escalation is that we're gonna, you know, we're at the limit, we're gonna stop here and we're gonna let nature take its course. If he can recover, he recovers. If he goes the wrong way, we're not gonna add anything more. There are a lot of people who feel really good about that. They're not making the decision's being made for them by fate, and absolutely. I think, but at the end of the day, it's when people start to apply it in the other way, rather than a guilt-reducing sort of empowerment framing or sort of a de-guilting framework, as opposed to legally empowering, I can class everything as a withdrawal, therefore you don't get to make any decisions. That's where I have the problem.
Yeah.
So, and I just wanted to point out in the Wanunu case, we delved into how other jurisdictions who do carve out religious, not exemption from a neurological determination of death, but some accommodation, like in New York State. And we had affidavit evidence from a clinical bioethicist in New York who was responsible for drafting hospital policies in that regard. And that's exactly what it was. It was the ability to, they would maintain the basics, air, water, food, but everything else, lines would just be no more monitoring, and you know, fluids that were running or medications that were running would just be allowed to run dry. And all of the religious communities, even the most orthodox, were quite content with those policies. And usually cardiac arrest would occur within roughly 72 hours. It'd be very unusual for it to go much longer.
That's very interesting. I see that we've come to 1 o'clock. So it's, I just want to thank you both so much for your time. It's been very interesting, and thank the audience as well for your excellent questions and for being with us, and to invite you to join us for our next seminars in the seminar series, all listed on our website. Thank you both, James and Daphne, so much.
A pleasure. All the best.
Likewise. Thank you so much, guys.
Goodbye, everyone.